Hi everyone, thank you for joining today's webinar. I introduced my guests quickly. We've got Rob Satagapkor from Stratco Property Group, who are an advisory firm for rent regulation. We've also got James Marino from Cut Marino, who specialises in DHCR proceedings. Thank you both for joining. So it's been over a year since the passing of the Housing and Tenant Protection Act 2019. And we've been given notice there may be some potential changes. Since these laws, the two value enhancement strategies my clients have been using have been repositioning of rent control units and parameter changes in relation to rent control units. So we're going to discuss, what the proposed changes are, and Rob, I'll let you take it over from here.
So related to the rent control changes, I'd like James to give a little bit of background on what the case law or the fact sheets were with the HCR on how to raise the rents upon vacature of the rent control tenant, and what might be expected going forward as far as changes related to the HCR's position on this. James, if you can educate us.
Sure, absolutely. Thanks for having me here. Now, for units coming out of rent control, it's an interesting history. Rent control is the older of the two forms of regulation, the other being rent stabilization. When rent stabilization was revived in the early 1970s, it was decided that there was going to be a merger between the two systems. They were going to let the two run side by side, and the merger was going to occur on an apartment by apartment basis. So when the rent control tenant left the unit, it was going to enter rent stabilization. And the question was going to be, well, what rent? The two types of systems were very different in terms of how they calculated the rents. And so they had to come up with some special proceeding, and it was called a fair market rent appeal. So when the rent control tenant left, the owner was able to set a rent known not as a free market rent. It could be free market rent, but it was really known as a fair market rent. So it was kind of a hybrid between the free market and rent regulation. And the owner was essentially able to charge whatever they wanted to, subject to the tenant's right to challenge in a fair market rent appeal. And if the tenant did not challenge in a certain amount of time, what the owner charged, whatever it may be, even if there was no basis for them to charge it, it was allowed to stand. If the tenant did file a complaint, then it was a special proceeding where the owner would be able to present comparables, which are similar sized apartments at hopefully similar rents as to what they wanted to charge to the subject unit. The owner was also allowed to get a special type of an increase above the rent control rent, and then add in the cost of the IAIs, the individual apartment improvements. And that has been the formula to date. There's been some changes with regard to what constitutes a comparable. The DHCR over the years has actually made it easier for owners to present comparables, and therefore easier to win a fair market rent appeal. And the reason for that is because as the number of rent control units decreases over time, and essentially the abandonment by owners of trying to obtain rent control increases, there was not a lot under the increase part of the formula left for owners. So the agency said, we'll make it a bit easier, and you can present comparables in an easier fashion. So that's essentially where we are today. That before these changes that we're now going to discuss, that's the process of a fair market rent appeal.
So what changes should we expect going forward, or what's being discussed?
Well, it's interesting because again, what we're fearful of is that the agency is going to lose sight of the history here, and lose sight of the fact that these are two diametrically opposed systems, and there has to be a fair way in order to merge the two systems together. Apparently, the fear is that tenants are not filing fair market rent appeals, that the owners are setting a free market rent, which again is their right to do, subject to the tenant's right to file a complaint. And apparently, whoever is proposing some type of a change is fearful that the tenants are not exercising their rights. It's a very strange way to look at it, because apparently what's driving is the fact that If not enough tenants are filing complaints, whoever is behind the policy change wants to see more tenant complaints, wants to see a test on the owner's establishment of whatever rent it is that the owner wants to set for the unit.
Who's making the decisions on the potential policy change? Which agency?
Well, the DHR is the agency that administers the fair market rent appeals. In fact, they have exclusive jurisdiction over the processing of a fair market rent appeal. You may be aware that there was a number of court decisions with regard to who has the primary jurisdiction over the processing of a rent overcharge complaint. And that has been held recently by the Court of Appeals in the Collazo decision to state that both the agency and the courts have concurrent jurisdiction. But that's over rent overcharge complaints. A fair market rent appeal is not a rent overcharge complaint. It's similar to it, but it's not. But so the DHR has the exclusive jurisdiction over the processing of a fair market rent appeal. Now, having said that, the agency can't make these, I don't believe as an attorney, that the agency can make the decision to take away the processing method, because it's in the actual statute, the Emergency Tenant Protection Act of 1974, which merged the two systems together. It's within that statute that the agency gets its jurisdiction from. So my belief is that the state legislature has to make the change, but the agency may very well try and make the change because they have over the years, as I stated earlier, massaged and changed the way that a fair market rent appeal has been processed. So they still have to, if they're going to make a change as a state agency, they're going to have to do it in that particular context. They can't just throw out the entire process. They would only be able to make minor adjustments, and it remains to be seen what adjustments they're going to make.
So if I was to summarize it, the State Assembly created the Tenant Protection Act in 1973, which basically brought back rent stabilization. They established, I guess, the rules related to the fair market appeal. So if any changes were to happen going forward, it would have to be a big bill coming from the State Assembly.
Yeah, that's my opinion, that it would have to actually be a bill. If they're going to make such drastic changes that it's not going to look like a fair market rent appeal anymore, that my belief is that change has to come from the state legislature.
Fine. Is there a proposed bill that came up over the last few months?
I'm not aware of a bill in the state legislature. What I'm aware of is the agency, the DHR, giving an indication that there may be changes in the way that they process these types of matters.
What's the time? Do you have a timeline of when this may be presented?
Well, my understanding is that it could come at any time, that they're working and thinking about it, but that at this point they haven't publicized that something is going to come out, and again, it could be very soon. It could be a while. I mean, they have to take into consideration how this is going to impact on their own processors, and they probably want to do some test runs before they announce their policy. I would hope that they would do something along those lines, but it could come immediately. It could be a good number of months.
Fine. Last thing before we transfer it over to Mitch, that's who's going to handle perimeter changes. If we have a vacant rent-controlled unit and we want to bring that unit up to market, what are the best practices that we can institute as an owner-operator to want to preserve that new rent and also mitigate the likelihood of an overcharge or potential litigation later on?
Okay, so what you want to do as an owner is when you get a vacancy, we would recommend that you do improvements. I think you would have to in a rent control apartment, because rent control by its very essence means that the unit has been occupied by the same person or family since at least 1971. So obviously a unit like that is going to need work. You do work for two reasons. One, under the first part of the formula, you do get an increase for the work in question. But the second reason to do it is because the new tenant coming in is going to be less likely to file a complaint if they feel comfortable and feel in their own mind that there's a basis for the rent that they're now being asked to pay for the unit. So a happy tenant means no complaints. So that would be the first thing to consider. The second thing is consider your comparables in a general sense, meaning that you want to get an understanding if the comparable is going to be the way that the rent is going to be set by the DHCR if there is a complaint. You want to know what that rent is going to be set at. So if, for instance, if the market is $3,000 and you have a comparable unit in the building that only rents for $2,800, you should be prepared to either only charge the $2,800 if you don't like surprises in the event of a complaint, or if you want to take a risk, and this is the opportunity to take a risk, you charge your $3,000 and just have it in the back of your mind that the rent could be set at $2,800 because that's your comparable. The risk comes from the tenant filing the complaint. And as I said earlier, the tenant may never file the complaint, and they only have 90 days to do so. So what you do in order to minimize your risk further is you do your initial apartment registration, which is a required document in actuality. You serve it on the tenant by certified mail. And it's not, and now it's going to be a little complicated. It's not certified mail return receipt requested. It's just certified mail. So it's not the green card on the back of the envelope. And what you do is you have your certified receipt addressed to the tenant, affixed to the envelope. You take the envelope down to the postal office and you have them stamp it with their purple date stamp. Then they rip off the receipt, they give it to you, and then you affix it and make a lot of copies of it, and then you affix the original into your file, staple it right to the cover of the file, and that is your proof of mailing. And that's how the 90 days is measured, from that purple date stamp by the Postal Service. And the tenant has 90 days from that date in order to file a fair market rent appeal. If they do not, if they're late or if they never file, and there's ever a question later as to whether you served it, that's your proof.
Got it. Okay, so I think we got substantial clarity on repositioning rent-controlled units and some light on potential legislative changes. If there is further changes announced, we'll have Mitch back. We'll have Jim back to give clarity on that. Now let's have Mitch give some questions related to perimeter changes, which are the other value enhancement mechanism that owners have brought. Mitch, if you can lead that.
Yeah, so thanks, Rob. So maybe we'll start, James, by just giving a bit of background on what a perimeter change is and what defines a perimeter change.
Sure, yeah. The perimeter change has to be a significant change. The perimeter of the apartment is the envelope of the apartment. It's the exterior walls of the unit. Significant change under the DHCR policy, which is known as the first rent policy, means that you're changing the perimeter to the extent that the old unit doesn't exist anymore, and that what you now have is a new unit. The easiest examples I could give is when you combine two apartments into one. Those two units will now cease to exist, and the new unit, the combined unit, will now take their place. The new unit begins its rental history from the point of creation, and since the concept of rent stabilization is all based upon what's known as base dates, base date is basically how far back you have to go in order to prove the legitimacy of a current rent. If the rental history of the combined unit begins, let's say today, you only have to go back as far as today in order to prove what you could charge. So whatever you charge today is going to be the base date for this newly created unit, and therefore that rent charged today is not subject to challenge, which is why it's known as a first rent. So there are other examples of expanding the perimeter. Duplexing is another way to do it. You build up on the roof, or you combine two apartments, or you build from a first floor down into the basement. That's also an example of a perimeter change.
I think you've answered my next question already, but So, are there any other changes proposed as part of these, these new legislation?
Okay, now this is going to be a little different from the rent control issue because the state legislature does not need to get involved in this. The reason for that is that the first rent principle is something that was created by the DHR's predecessor agency, the Conciliation and Appeals Board, which ran rent stabilization in New York City until 1984. Then the state DHR took over. The CAB created the policy exactly because there was no rental history for the newly created unit. So they said administratively, well, we have to come up with some way to determine what the base rent is. So they came up with the first rent principle. So it's been around since the early 1980s, I believe. It could even go back into the late 70s. So it's been around for 40 some odd years. And now the DHR is talking about changing.
Okay. So, and also, who's typically involved in this process? Do you have your landlord representatives or?
I don't know and probably do not believe that they're seeking landlord input on this. The DHR is under pressure from the tenant groups with regard to the tenant groups call these Frankenstein apartments. For some reason, they believe that these combination of units or duplexing of units just is a monster. I don't know exactly why they think that. Probably it just has to do with the fact that they view it as an end around by landlords to get around rent stabilization. My opinion, what it really does is it creates a type of a unit that people that want to live in, let's just say Manhattan, can't do unless they have a larger unit. And what I'm talking about is smaller families. I'm talking about people who, have gotten married, started to have children, and they need more than just a very small 900 square foot apartment in which to live because they have a growing family. So a duplex or a combined unit would be exactly what that type of a family would want to have. But for some reason, the tenant groups view this as an abhorrent practice, and they're putting pressure on DHR to change the first rent policy.
So what do we do for those that are in the midst of renovation or they're waiting for permits and they don't want to get stuck like they did with IAIs in the middle of renovations in June 2019? What would you recommend besides getting it done as quickly as possible for those that that have a business plan predicated on this?
Well, I think that it's just going to be conjecture on my part as to what to expect under the new policy. But I think if the owners can just get an understanding of what those possible changes are, and again, be ready to have those changes implemented, there's no other strategy I can think of. I mean, look, the one thought is that they're just going to take, if you could do combination of two units as an example, you're just going to have the old rent of the one apartment and the old rent of the other apartment added together, and then come up with the new rent. That's probably going to be insufficient for building owners because they didn't like the old rent under either one. Why should they? The problem with that, as far as a policy goes, if that's going to be the new policy, is that it completely does not take into consideration the fact that what you're doing is you're eliminating basically one kitchen area from one unit and creating a otherwise non-existent living area. So in other words, if you have a 1-bedroom and a 1-bedroom, you don't create a 2-bedroom, you basically create a 3-bedroom because you're taking away a kitchen, you have room for another bedroom. So that, 3-bedroom is, has a much different marketing aspect and a much different value aspect than 2 1-bedroom apartments. And where the concern is that the DHR, if they're just going to combine the 2 rents together, that doesn't take that, into consideration. So that's just one problem with combining the 2 rents together.
Okay, so that possible option or way it may shake out is it doesn't make any economic sense for owners because the cost of renovating won't be justified just by combining those two rents. So to summarize, there isn't clarity on what is being proposed or being negotiated between, I guess, the tenant advocates and DHCR. And if someone is in the midst of doing this, they should probably get it done as quickly as possible. And if they're planning on doing it at some point in the near future, if they want to err on the side of caution, they should probably wait until further clarity is on this, right?
Yeah, that's a good summary. Yes, I agree with that.
Okay, Mitch, if you can close today's session.
Yes, thanks. Thanks for James' retirement. Really appreciate it. Lots of great insights there. Lots of talking points. I'm sure you could talk on a lot longer. Maybe have to have you back once things progress further. Thanks again, Robert, as well. I'm just going to share our contact information for anyone that has any further questions quickly.
Okay, you guys are there?
Yeah.
All right, I think this was exceptionally fluid.